Welcome to my Remedies Law workshop. I'm Goldberg, your tutor and your host. So what is Remedies Law in general, right? What do we need to know about this exam and what do we need to know about, the key components? Have we written criminal law, all of us? Have you done the chapter called sentence hearing? Right?
Yes.
So civil trial, the tail end is the remedies, right? Civil trial, the tail end is remedies. So it is all about the sentence hearing for a civil trial, whether it is coming from tort or contract. So there are two bigger things you need to understand. If you haven't written tort, don't worry, you are not going to establish the component of the tort. But can we identify whether there is a tort and contract? So if we had an oral contract, you came to my class, I advertised, so there was a contract was established. So whatever we learned back in law school with regard to contract, that's enough for our Remedies Law exam. Are we clear? So don't panic. Only thing we need to understand, the number one rule in the Remedies Law exam, as Ivneet was saying, there is no structure. So the point is, first of all, look in the exam situation whether you are dealing with a contract or a tort. Are we clear? So the first issue. First issue is contract or a tort. And remember, we had one thing called air of reality in criminal law. So similar thing we will establish over here in remedies. So that would be in light of mitigation. If it is a contract and things like that, there is a mitigation and the liability, correct? We have to establish that. So these are our, remember when we going through an exam situation, we'll be like, oh, what should I do, correct? So the first thing we say, it is an equitable scope, and equity is unlimited, right? But equity, same as subjective mens rea, it is very, very personalized thing. Are we clear, Natalie? So every situation has, that's why the subject looks all over the place. It looks like, oh my God, what am I going to do in this situation? So first we break it down into two things. Tort, one route, unlimited scope. There are only basically two types of torts. If you have gone through the second component of my remedies part 2 of my notes, even if you haven't purchased my notes and you don't have it, so I'm going to give you a quick refresh. There is a difference between public wrong and a private wrong, right? So if I invite you to my house to attend a workshop, right, that can be a public nuisance due to COVID these days, because people can be offended, right? So it's not just my neighbor's issue, right? It can be the whole locality's issue at that level. So we can definitely argue between, so we are talking about the tort first. So the tort, private or public. Private, you have to kind of go over the counter to establish things and this and that, right? But for public wrong, it's very likely to get some kind of help from the court, correct? Another thing, so that is what the tort is. Another question which students normally ask me in my classes, and that's like number one in our sample question as well. Is there a way to stop a crime from happening in the law of remedies? Remember that guy who is dealing with the drugs, and he's, kind of going through the stuff. And so the person who is, concerned neighbor, can he stop? So there is no way that you cannot stop a crime from happening in the law of remedies. I'm just giving you introductory points and then we'll go more in detail, right? So law of remedies is equitable. It's like put things in balance between us, right? Contract or tort. Tort, ask yourselves two questions. Can you, even if it is private wrong, can you convert it into public wrong and kind of highlight it and support the facts? Are we clear, Simon? Are you following it? Marjan, do you have a question, or do we have clarity over here on this point? So the first thing in remedy is break it down into two components. Contract route, What can be the contract route? I told you like I will come and fix your kitchen counter, correct? I will do. So that's always a contract in the, whatever we read in the law school, that's sufficient over here to establish whatever the contract says. So the wrong tort route, no contract. It just happened. I never promised you anything. So that definitely going through that route. So the first question we are asking ourselves, what is the route between A and B? Are we clear? And then when we establish this and it is a sentence hearing with subjective mens rea and rare of reality, this is what nutshell law of remedy is. To absorb, to understand, to reflect and tie the loose ends, right? Now, next thing we have over here is we will go through what type of tort has been considered, what type of, anybody like to read it with me? This one. Natalie, would you like to read it? In a contract situation, we don't need to explore the logic and justification of the...
NCA Remedies.
Correct.
In a contract... Pardon me?
Yeah, go ahead, please. Sorry. Keep reading.
Okay, sorry. In a contract situation, we don't... Sorry. In a contract situation, we don't need to explore the logic / justification for damages. We have clear contract, and the law of contract allows commercial parties to sue for broken promises and seek damages. The law of equity allows damages to be an alternate route for specific performance in almost all situations, unless a plaintiff clearly abandons the damages route in his or her pleadings. The secondary question is the quantum of damages or measure of damages in any equitable situation. We do not need to dig into a full array of damages analysis when there is a clearly established contract.
Period. Now, Evnit, would you like to add something over here?
Sorry, you mean read the rest? Or?
No. I'm just saying, would you like to add to this para, break it down into the more details? Are we clear? Everybody, Simon, do you have clarity what we are trying to say over here? So we are saying, first of all, we will look at a contract, correct? If the contract is there, we don't have to go into equities and say, oh, it is an equity, it is equitable, this and that. So we will just strictly follow the contract and try to read it around the contract, right? So that's the first way of tying the loose end at that time. So anybody who has not done pleadings, it simply means when you file your civil case in the court, it's your story how you put it in the court, correct? It's your main charging document in the civil case. Pleading is a charging document in the civil case where you are saying, Mr. A, I am suing you for X, Y, and Z, right? So the first thing we need to understand in the specific performance route is, specific performance is almost always available for a contract law situation unless you have abandoned it. If you sue just for damages, it means your specific performance has been dead. If you sue for specific performance, damages are alive. So write it down. In the contract law situation, in contract law situation, if question informs us the content of pleading, then we need to review the content and see if plaintiff is only suing for damages or he is also suing for specific performance. The law says, the law establishes whatever, that if you only sue for specific performance, you can always convert your claim into damages, and damages are always available at part of it. Are we clear? Now the next component we have over here is the tort, correct? So basically we are talking about two types of torts, nuisance and trespass, which is all normally there, correct? Trespass is the deliberate unlawful invasion of another person's property in order to gain benefit without the owner's consent, correct? nuisance is unreasonable use of one's property. I am doing some kind of, you can say I'm doing some kind of burning some kind of special wood or something for aromatherapy or something. That can be nuisance for you as my neighbor, right? So, and we have Rashpinder, the last girl. Hi, I'm talking to you. Yeah, so do you have any question? So basically we're talking about 2 or 3 types of torts. One is trespass, nuisance, and then we can talking about financial issues. So this is one way of looking at the first question we have in the sample exam. We can talk about the negligence. We can talk about the nuisance, and we can talk about the trespass, because the customers were jumping over that girl's property or the guy's property, right? And another thing we have over here is we will go, I will provide you this document, don't worry, this one you don't have to copy. And you can work on your answers on your own, and then contact me if you need more help. So we were talking about the trespass and the nuisance, and then we have the jumping over the fence and all that stuff. Now we are saying whether or not he will be getting any equitable relief, what the criminal business in the apartment building. For that we have, if you remedies part 2 of my syllabus, in that we have this provision regarding, I don't have that in my top of my head, but I'm gonna make you go through that. So the injunction we can seek against a person, there is a specific name for injunction that is called the specific name of injunction, where you can stop the crime. So there is a case law established that we can stop the crime from happening, and we will add it over here as well.